Alrighty, welcome to the court part 3. In this section, we're going to talk about different interpretive theories about exactly how the Supreme Court might read the Constitution, and for that matter, federal law, but we'll talk here mostly about the Constitution. And then we're going to talk about some of the cases where the Supreme Court has challenged presidential power. There aren't many of them, but there are a handful that are quite notable. I think that's all we're going to do in this section. I will mount the court part 4, in which I talk about the Nevada Supreme Court. That'll be extremely brief. All right, let's go. So one theory about how the Supreme Court justices might read the Constitution, interpret the Constitution, is the school of thought that says original intent should govern this process. The best known advocate of just such an approach, Associate Supreme Court Justice Antonin Scalia. You might want to check out that 8 or 9 minute YouTube clip in which he debates this issue with his colleague Stephen Breyer. Original intent is the idea that how the court reads the Constitution should reflect how the founders read the Constitution, what exactly they intended back in, let's say, 1787, or if you're talking about the Civil War amendments, the mid-19th century. So whoever authored the words in question, you should look at what their intentions were and stick to those right up to the year 2015. So original intent, the idea being that you ground the meaning of the Constitution in the moment in which it was created. You do not give justices any degrees of freedom to change that in any way, unless, of course, we, the people, decide to amend the Constitution themselves through the formal amendment process. As I think I've suggested, bottom line, that school of thought, although it's an interesting school of thought, and there's some things to be said for it, of course, it has not won the day. Indeed, I've suggested, and will repeat, that I think that the Supreme Court has creatively reinterpreted the Constitution over time. I think that's a good thing. Others would disagree with that, of course. But what no one can disagree with is that is exactly what has happened. That original intent as a theory has not won over any significant number of justices ever. So there's that. I mean, there's all sorts of issues with original intent, right? Do you maintain this rigid approach that sort of freezes things at one moment in time? Is it simply a cover for some ideological agenda? Because not surprisingly, if you're relying upon, let's say, the Founding Fathers, a bunch of propertied older white guys, you're going to tend to get results today that are quite conservative by modern standards. And so, right, is it coincidental that Scalia is both politically conservative and a big fan of original intent? Or does he just use original intent to mask his deeply ideological agenda? Because all the justices have some sort of an ideological agenda. Scalia is by no means free from that. And is it just coincidental, again, that his theory of interpretation matches up beautifully with his own political ideology and how he wants most of his cases to come out? So it's an ongoing debate. I think always the court should look at, when they're considering some issue related to the Constitution, they should always go back and look at what did the founders intend. Although we'll see that often, right? I mean, we've seen that often the founders disagreed themselves over exactly what they were doing. That's why we got the Federalists versus the Anti-Federalists and the Federalists versus the Jeffersonian Democratic Republicans. They all believed in the Constitution. They just believed in different versions of the Constitution. So right from the beginning, that broad language lent itself to intense debates over exactly what they were meant to produce in terms of policy. So that right there is just a really quick example of some of the difficulties of original intent. Sometimes the evidence is sketchy, right? There was no written record of the convention back in 1787. We get Madison's notes, but those are Madison's notes. There were 50-some additional people there who each had their own view on what was happening and what was intended. So all sorts of issues there. Nevertheless, it is useful to go back and say, hey, do the Federalist Papers shed light on the meaning of due process? What about the Anti-Federalist Papers? Do they shed light? They lost, but they also helped to include a Bill of Rights. right? You can look at all sorts of evidence that can go in different directions. So it's very useful, though, to look at that, no question about it. But as a definitive theory that has won over a substantial number of justices has never happened. The approach has clearly been less originalist and more, we'll see, living constitution, evolving document. Another interpretive theory is that of strict constructionism, the idea being that the court should stick very closely to the exact words of the Constitution in deciding contemporary cases. At some level, right, who's going to have a problem with that? Sure, strictly construct this language. The words should mean what they say, but very quickly we see that that runs into some problems, right? Because the only words that are super precise make things easy, but that's usually not the case. You have to be 35 to run for president, 30 to run for the Senate, I think 25 to run for the House. That's clear, that's exact, right? But more often we have things like equal protection of the law, due process of law, regulate commerce. These could mean any number of things, right? So right there, strict constructionism leaves you in a little bit of a vacuum because often those words do not lend themselves to strict construction. They articulate only very broad concepts. And again, this is often an argument made by political conservatives as a way to limit judicial activism. The court should be held by the exact words of the Constitution, but we see again that so often the words are not very exact, so that's a problem. Another problem is inconsistency. Right? Again, I think justices, like anybody else, they have their political views. They want to see those political views validated in how cases are decided, and they're going to reach the result that they want, regardless of what road they need to take in order to get there. So look at, let's say, the Second Amendment, the right to keep and bear arms. Justice Scalia, who's also an advocate, at least at times, of some form of strict constructionism. Do we get that in the D.C. v. Heller case or the McDonald v. Chicago case? Arguably not. Because if you wanted to favor strict constructionism, you would say, hey, the Second Amendment means what it says. A well-regulated militia being necessary to the security of a free state, the right to keep and bear arms shall not be infringed. Right? So some would say, hey, to the extent that you need a well-regulated state militia, then you can keep and bear arms. But if you're just an individual who wants to own the arms of your choice and do what you want with those arms, hey, sorry, not protected by the Second Amendment. It might be protected by some other federal law. It might be protected under a state constitution. That's cool. But it's probably not protected under the Second Amendment if you read those words strictly. And yet, what do we get in those cases, right? Conservatives arguing for a much looser reading of that language. Hey, that's not exactly what it means. We think there's some looseness there, some degrees of freedom. Yeah, they said a well-regulated militia being necessary to the security of a free state, but that wasn't exhaustive of what was included in the right to keep and bear arms, blah, blah, blah. You can make those arguments, and maybe they're convincing, but it's not strict constructionism. It's not. So there's that. And also, right, you might get this sort of an issue, strict constructionism regarding the recent case involving the Affordable Care Act. Right, conservatives wanted to strictly construct that language and say, hey, it says federal subsidies in states where the states made up their own health insurance exchanges, and it doesn't have parallel language when it talks about states where the feds will set up the healthcare exchanges. So that means no federal subsidies for those people, strict constructionism. There's a case for that. There certainly is a case for that. But does that counter the clear intent of Congress in that legislation? It surely does. So you could strictly construct that law and come to that result, but we know that the court rejected that because they said, look, what's more important than strict constructionism is the intent of Congress. Some form of original intent, I suppose, is what was used to decide that case, right? A result favored by liberals. Congress clearly intended there to be federal subsidies for all who could not afford health care. They didn't mean to make some arbitrary distinction between people living in these states, people living in those states, and yet Scalia, coming back to original intent, he's never used original intent for federal law, only for the Constitution. not entirely clear why he draws a distinction between those two categories. But if you did take original intent and apply it to the Affordable Care Act case, that's a result that favors the liberal point of view, right? And yet conservatives mostly rejected that, with the exceptions of Roberts and Kennedy. Scalia, Thomas, and Alito, the strongest advocates for original intent, said screw original intent. Let's go with strict constructionism, because original intent, right, wouldn't get the result that they wanted. So once again, so often, whether we're talking about strict constructionism or original intent, are these simply masks for a deeper ideological agenda whereby the justices will go down whatever road, whatever interpretive road will get them to the destination that they favor in relationship to their politics. Finally, let's talk about judicial interpretivism, which I argue is the school of thought that has effectively prevailed over the years. And that is the idea that we treat the Constitution as a living document. That even if you want to argue some form of originalism, it could be that a la Jefferson, what the founders intended was that each generation would fight their own battles as to the meaning of the Constitution. And part of that would involve some role for the U.S. Supreme Court. So this is the idea then, right? A Constitution as living document, that it establishes very broad principles, but within that, there is an invitation to struggle over the exact meaning vis-a-vis things like public policy. And the argument is, look, realistically, pragmatically, perhaps it's not ideal, but it gets the job done at the end of the day. This is a way to keep an 18th century governing document that otherwise would have gone out of, would have become dysfunctional a very long time ago, right? Would not have permitted the New Deal, would not have permitted many forms of civil rights, would not have permitted or favored broad suffrage, would have maintained some form of slavery. Hey, look, given how difficult it can be to formally amend that document, this has been a way to get it done. The Supreme Court creatively reinterpreting it in a way that fits contemporary politics, that reflects, indirectly, perhaps, the will of the people. Right, so the idea here is that, hey, the founders intended us to struggle over the exact meaning with each new generation. The court plays a significant role in this. That is judicial interpretivism. That is understanding the Constitution as an evolving document, Now that makes Scalia crazy. Scalia hates the idea of evolution unless it comes to formal amendment. He has said, I do not evolve. He's very frustrated by the massive fact that the court has obviously gone that direction over the years. And he's been unable to prevent it, unable to bring it back to some kind of originalism. That although there's much to recommend that school of thought, it's pretty deeply flawed. And the court has said, look, we're going to draw from that selectively, but mostly we're going to go more of a judicial interpretivist approach, Constitution as living document approach. And in a way that I believe has largely reflected the will of the people. Not always, but generally speaking. All right, but again, right, I would say that there's to be said in favor of judicial interpretivism in some way. I think it's intellectually more honest than some of those other theories, because it really says, look, our politics do matter, and that is going to shape how we view the Constitution. Let's acknowledge that up front, put some boundaries on it, perhaps. A certain fidelity, of course, to the principles of the Constitution, but hey, realistically, we're flesh and blood human beings. We have our own political preferences. We're going to try to move cases in our direction whenever we think we can plausibly do so. And let's simply endorse an interpretive theory that validates that whole idea. That we are going to treat the Constitution not as silly putty or endlessly flexible, but as significantly flexible in terms of crucial details. Finally, let's talk briefly about what role the Supreme Court has played in relationship to the president. In general, I would say the court has been loath to intervene too much in relationship to the president. The president is quite powerful, has the power of the sword. Historically, when the court has made policy, it's typically gone after weaker actors, if you will, especially state and local governments, occasionally the U.S. Congress, but least frequently by far has been the presidency. The court doesn't like to mess too much with the president, right? We've seen that the president can make it difficult to enforce Supreme Court decisions. There was Worcester v. Georgia from back in the 1830s, in which President Andrew Jackson said that he would not enforce that decision that was pro-Indian, anti-state, and the court could do nothing about that. We saw the President Eisenhower waffling on Brown v. Board of Education, and that created all sorts of problems for that decision. So in general, the court has been leery to interfere too much with the president. But the cases where they have, Youngstown v. Sawyer, 1952. President Truman, in terms of prosecuting the war in Korea, had seized the nation's steel mills to prevent a labor strike and maintain government ownership of these steel mills. Ultimately, the court said, no, you can't do that. Your powers as commander-in-chief are vast, are great, but they only extend to the theater of war. Where is the theater of war? It's over in Korea. Does that include the power to seize steel mills back in the U.S.? It does not. It does not. So while the court respected the president's powers as commander-in-chief, they said they only extend to the theater of war. Truman had overreached. U.S. v. Nixon, we've talked about that case. Nixon invokes executive privilege, tries to avoid handing over unedited tapes of Oval Office conversations. The court ultimately says, unless there's some really compelling reason for maintaining that privilege, we are not going to recognize it as constitutionally legitimate. There are limits on that power. Led to Nixon's resignation. Clinton v. Jones. Clinton was being accused of sexual harassment of Paula Jones when he was governor of Arkansas. Clinton had argued, hey, a couple arguments here. One is, I am the president of the United States. I cannot be subjected to these sorts of harassing lawsuits that are politically motivated. And the court said, no, you can't argue that. You know, you're not above the law. Even though you are president, you're still subject to civil prosecution in a case like this. And Clinton said, all right, well, my backup argument is I'm president of the United States. I don't have time for this right now. When I'm done being president, then she can bring her lawsuit. Otherwise, it's going to interfere too much with my powers as president, my ability to be an effective president. And again, the court said, no, sorry. You cannot delay this case until you're no longer president. Again, you are not above the law. And so ultimately, of course, Jones did pursue her case against Clinton. However, I believe immediately a federal trial judge threw it out as insufficient evidence. And I think it was rejected on summary judgment, which means that in the view of the judge, at least, Paula Jones had no significant case whatsoever. Nevertheless, right, the underlying principle is presidents can indeed be subjected to civil litigation. They cannot invoke their power as president to avoid it completely or to delay it. They have to deal with it the way anybody would have to deal with it, Clinton v. Jones. And then finally, the Guantanamo Bay cases. In the context of the war on terror, post 9/11, W. Bush, the detainees at Guantanamo Bay. Bush had created military tribunals for these detainees. The court said these tribunals are not sufficient, do not meet due process. Yes, these are not U.S. citizens, but due process applies against the government whenever it deals with human beings. And in their view, these military tribunals did not meet the Geneva Convention standards, did not meet the Uniform Code of Military Justice, did not meet due process standards. Congress came back, validated these tribunals, and the court said still not good enough. So at least the message was that indeed, if you're going to do this sort of approach to the war on terror, you must provide detainees some significant form of due process. Not necessarily access to a civilian Article III court, but something better than military tribunals in which the prosecution is heavily favored and the defense is crippled in terms of what it can argue and how it can argue. Bush never really acknowledged these decisions, never went forward with any of these tribunals, I believe, just sort of treaded water until he was no longer president. And now, of course, Obama has inherited some of this mess over there at Guantanamo Bay. But the court has said, you can try these people, of course you can, and you don't necessarily have to try them in a civilian court, but you've got to afford them some minimum level of due process. Okay, so again, all four of these cases, we see the court holding the president to a certain legal standard that shows that indeed the court can check and balance executive authority.